So, dear ladies and gentlemen, thank you for coming to our seminar of Geopolitical Tuesday. I would like to thank especially our guest, Dr. Malwina Kołodziejczak from War Studies University, for accepting our invitation. Welcome to our cycle. And I'm very happy to welcome you to her lecture entitled Legal Problem with the Extraordinary Measures in the Republic of Poland. My name is Kinga Torbicka. I'm the research fellow at the Center for French Culture and Francophone Studies at the University of Warsaw. For our audience on the Zoom, please turn off your microphones and cameras. And for your information, this conference is recorded and will be available on the YouTube channel. At the beginning, I will present our guest. Then Dr. Malwina Kołodziejczak will hold his lecture, and after we invite you to question and answer session. Now let me present our guest, Malwina Kołodziejczak. You received your PhD in Security Studies and your Master of Law with International Professional Internship Fellowship Projects, Educational Erasmus Courses Fellowships, and Voluntary Experience. You are the author of nearly 50 publications, speaker of nearly 70 seminars and conferences. Your scientific interests are Commander-in-Chief, Extraordinary Measures, War, Recognition according to International Public Law, National Security System, Constitutional Law. And you work as the Assistant Professor at War Studies University. And you are also a PhD candidate in law at Cardinal Stefan Wyszynki University. Today, Dr. Malwina Kołodziejczak will present some binding definition occurring in Polish legal acts, but also in the wider context. As for terms such as aggression, state of war, martial law, but also entities in public international law. Furthermore, she will refer to the hierarchy of sources of law in the Republic of Poland, indicating where a lack of definition is and where it seems that they are unnecessary according to the rule of legislative technique. Finally, she will also refer to the presence of the definitions in legal regulations which are related to extraordinary measures in the Republic of Poland. The last point is important because the correct interpretation of some key definitions depends on the possibility of introducing one of the extraordinary measures. After the lecture, we invite you to the question and answer session. You could write your comment and questions on the chat. So now I invite Malwina Kołodziejczak to present his lectures. So Malwina, the screen is yours.
Thank you very much. Screen is mine. Nice. Thank you for inviting me. I'm really glad that I can be here, maybe not really here, but unfortunately I couldn't come to your nice place, but my university, because my university is, to be honest, maybe not so far away, but still the other side of Vistula River. So unfortunately, it took me too much. So I just finished my classes. So thanks for Zoom, to be honest. So dear students and dear guests, as Kinga said, today I would like to present a lot of things. I hope that it will be quite interesting, but we will see. Anyway, I think that it's quite important, especially during that time, because during last 2 years we had some complicated thing with COVID pandemic, then especially in Poland with something like one of the extraordinary measure, I mean extraordinary state. So right now, unfortunately, so it's almost impossible, like we have war, traditional war next to us. So these 2 years is really a lot of examples, like we can or we could use the extraordinary measure in our country. So today I will talk about it. And first of all, I will present some legal articles, some legal acts, and then I hope that we will have time to talk about it, and we will talk about some examples. Okay, so as Kinga said, I'm working here, and I said it also, but I would like to say something about extraordinary measure and why I'm talking about it. It's not only because it's very important case, or we have during 2 years very important cases according to extraordinary measure, but my main topic is commander-in-chief. So because interested in commander-in-chief, so I had to interested in extraordinary measure, especially martial law, but also about war. So even if commander-in-chief is or has first place in my heart, still extraordinary measure and war, they are also there. So that's why I'm here today. Short plan of our lesson. First of all, very short information about the definition, about procedure of introduction, then some legal problems, or maybe one problem. Then I would like to maybe show you or ask you, what do you think about hybrid warfare? And if, because of the extraordinary measure, we can say something or find a solution for hybrid warfare. Then I will show you some example situation, and next we will go to conclusion. So as you probably know, the hierarchy of legal acts of Poland, it's like that. So first of all, we have constitution, then we have statutes, then we have international agreements, and the last place is regulation. Of course, here, I mean, under the schemat, we can also put something like smaller regulation, something like a local act. But here is the most important legal act for whole countries. So as I said, constitution is the first. So today I will talk a lot about constitution and also a lot statutes. In normal situation, it's like that first place has constitution and then statutes and then international agreement, but sometimes international agreements are more important than statutes, and sometimes, and this is the most popular situation, that this ratified international agreement are on the same level like Polish statutes, because first of all, before we ratified international agreement, we have to also give them agree in statutes. So to be honest, in our legal system, and then we have two acts. First, statutes that we agree that we will ratify this international agreement, and then this ratified international agreement. But the most important part for us for today is constitution, statutes, ratified international agreement only because of the war. Constitution, we have three and only three extraordinary measures. So it's martial law, state of emergency, and state of natural disaster. And of course, we can say something like the war, time of war, warfare is a very special situation, and of course it is. But according to our constitution, we have just three extraordinary measures. As I said before, martial law, state of emergency, and state of natural disaster. So the state of war, which we also have in our constitution, and unfortunately we have different kind of this situation like time of war, it's completely different legal institutions. So only three that I show you before are extraordinary measure. So what about war? We classified it to extraordinary measure. As I said before, not really. What's more important, in our constitution, we have more different terms. It's not really war, only war, because we have war, we have state of war, we have time of war or period of war. We have also aggression, armed attack, what is very important, entities. So what's the difference? War is colloquialism, because according to our legal acts, we have only state of war and this time of war. And unfortunately, it's not the same. State of war is just information for, let's say, international world that we are in war with some other country. And we only can declare this state of war because of the armed attack of our territorium or armed attack to territorium of our alliance. But it's very tricky because in our constitution, we use the words aggression. But as you probably know, because of the last days, aggression, it's not the same what's armed attack or especially what war means. So we had problem with this and with the binding definition, because first definition of aggression, it's true, we could find in even 1933, it was London Convention, and then in resolution of General Assembly, but it wasn't binding definition of aggression. But finally, in 2010, we had a new Article 8 bis in some act statutes of International Crime Tribunal, and there is finally binding definition of aggression. And in this definition, we can find that armed attack is one of example of aggression, the worst one. So to be honest, in our constitution, we have, let's say, small error, because it means we want to take this article literally, that only because of the armed attack we can declare state of war, and because of aggression, and we have few of example of aggression according to this new definition, we can declare, because of aggression to our alliance, we can declare state of war. So of course it's not true, and it really maybe not official mistake, but we just copy this article from our historical constitution. So in official state of war, just because armed attack on our territory, or just because armed attack of our alliance territory, we can declare this state of war. What's important? It's nothing changed. It's only information according to public international law that we are in war in other country, and we can't declare in different situation it. So we can break the international relationship with this country. We can break our economic relation. We can break diplomatic relation. And of course, we can fight, yes. But on our internal ground, we can do nothing because of the state of war. So just because we have to declare something more. So we have to declare, for example, time of war. And this time of war is completely different institution, and is very, to be honest, it's a super Polish institution, because only Poland created this kind of use of this war term. And this time of war, we declare because of the armed attack, when we can, when we should fight and defend our country. But especially during that time, for example, we can appoint commander-in-chief. So it's very important guide during the war. So what's more, as you can see here, we can finally have a martial law. So it would be perfect that before state of war and before time of war, we can introduce martial law. And I will be talking about it later. What is also very important, according to public international law, war, especially state of war or time of war, we can only declare only if two states are fighting. So if other states attack us, we have war, and we should declare of war and introduce this time of war, and before introduce martial law. If somebody else wanted to attack us or attacked us, according to public international law, it's unfortunately not law, it's not war, it's just conflict. We can say that it's international conflict, an international conflict, and internal conflict, but if it's not other state, for sure, according to public international law, it's not war. What's more, even it has, because according to this new definition, not so new, because from 2010, aggression can be doing only, or can be created only because of from one country to another country. So also aggression is something like a prelogue to war. If it's not state versus other state, we can't say that this is war. Okay, so let's go further. Extraordinary measure. As I said before, we have three: martial law, state of emergency, and state of natural disaster. The most important information, and not every constitution, especially in the European Union or in Europe, have the same construction of this article. is that part, if ordinary constitutional measures are inadequate. Because for sure, we know that situation of particular danger is very important here. But we can say that a lot of things is or can be particular danger. But this second part, if ordinary constitutional measures are inadequate. So because of this second part, we had quite problematic time, especially during the COVID pandemic. Also, the situation in our border, because of this one, was quite interesting. But I will talk about it later. So what mean this inadequate, insufficient? So first of all, there is particular risk. It's the permission sine qua non. There is a particular risk. Ordinary constitutional measures have proved insufficient. But how? How we know that we have proved and it is insufficient? To be honest, we don't know. It's quite unclear because it's very subjective topic and institution, and very political institution. So it's only because of the opinion of Council of Ministry and President that this time is super particular risk and ordinary constitutional measure have proved insufficient. But what more? What should be meaning that constitutional standards turn out to be inadequate because they had been checked, used, and exhausted. And it's not enough. So we have to try some extraordinary measure, because a lot of tools, what we have, they are just not enough. But it's not so easy. So, according to the Constitution, in the case of external threats to the states, also armed aggression against our territory, or aggression against our, as I said before, our alliance, President, at the request of the Council of Ministry, declare state of martial law. And it's possible to declare it in a part or whole territory of the state. It's our constitution. And we also don't know for how long we want to declare martial law, because it depends on the threat. So this is, I think, clear. So what we have in our statute. So in this, we repeat some part from Constitution, because we have this external threat, we have also this armed attack and the aggression, but we have to remember that it's not mean really aggression, but it's also mean armed attack. And also in our statute, they add some action of terrorists and action in cyberspace. So, to be honest, because we know right now what hybrid warfare mean, so action of terrorists or action in cyberspace, we can find that this is part of hybrid warfare. It's very important that we also look here, external threat, because it's very tricky too. I'm really glad that we have binding definition, because I'm a big fan of binding definitions, but unfortunately, this definition is quite too open. So we can find here a lot of information, and to be honest, really a lot of particular risk. We can classify it like, yes, extent, like some cause that we can introduce martial law, but unfortunately it wouldn't be so easy. So external threat by the state refer to paragraph 1, so this one. It's also understood deliberate action detrimental to the independence, integrity of the territory, important economic interest of the Republic of Poland, or efforts to prevent or serious disturbance of the normal functioning of the state undertaken by external to the entities. And what here is important? So, of course, it must be something, some action against to our independence, of course, against to our integrity. Of course, this is quite clear. But please tell me, what does it mean important? Why we put it here, important? Why not, for example, very important, or the big, or the skull? We don't know what important means, to be honest. Let's go further. Here, for example, some serious disturbance of the normal functioning of the state. Normal functioning of the state. So if one ministry has problem, is some problem with the normal functioning of the state? And for example, if we had some action in cyberspace and the page of a lot of ministry don't work. So the pages in a lot of ministry don't work. So it means that it's very serious disturbance of the normal functioning of the state. This is another question. And finally, economic interests. So if we have problem with some gas, oil, and let's say we have 10% of our reserve, it's really big problem or serious disturbance to the normal functioning of the states? Unfortunately, dear students, we don't know. And as I said before, the best answer for it is to remember that the extraordinary measure, not only martial law, but also the two other, is political institution. So it depends on Council of Ministry and President. But here, the most important things is the last part. So this action is because some other external entity did it. So unfortunately, some group of terrorists, some group of hackers, not entity. So according, again, to public international law, external entity, it's only other state. So if it's not because of the action of other state, for us, it would be very, very hard and probably impossible to introduce martial law. Or here we have this information, and what's more, in our constitution we have this external threat, but unfortunately we have also something like a direct external threat in different meaning and in different article. And to be honest, we are trying to understand what means external threat and what means direct external threats, because sorry, but it's not the same. The second emergency state or extraordinary state, extraordinary measure. The second extraordinary measure is the state of emergency. And state of emergency should remember that we can introduce this state of emergency not because of something external, but because of something internal. And this something internal, it's in case of the threats to the constitutional order, to security of the citizens, or against to public order. And the procedure is the similar like before, because president at the request of the Council of Ministers can introduce this state of emergency, but here we have the time, it's not longer than 90 days, and once we can extension this period, but no longer than 60 days, but only once, and with consent of the same. And the statute's definition is the same like here, just like before. In this second definition, we added action of terrorists and action in cyberspace. So in every kind of extraordinary measure, we have this action of terrorists and action in cyberspace as a cause to introduce some state of extraordinary measure. Finally, state of natural disaster. It seems that the third one, it should be the easier one, but it's not so easy. So, in order to prevent or remove the consequences of natural catastrophe or a technological accident exhibiting characteristics of a natural disaster, the Council of Ministry may introduce for a definite period no longer than 30 days a state of natural disaster in a part of or upon the whole territory of the state. An extension of a state of natural disaster may be made with the consent of the same. And in that case, we don't have information for how many days. So it's also quite good information. And also in statute, we have information. So because of amendments, the parliament add the action of a terrorist and also action in cyberspace. So in every kind of extraordinary measure, every kind of state, we have this action of terrorist and action in cyberspace. So how we know which kind of state of extraordinary measure can we use because of the terrorist or because of the action in cyberspace? We don't know. Short questions. Why? Because it depends on the other information. Yes. So if it's external entity, probably it would be martial law. If it is because of some internal action against our constitutional system, probably it would be state of emergency. because of, for example, remove some catastrophe or technical accident, probably it would be state of natural disaster. But also important, in our statute, we have different information that also we can introduce this state of natural disaster because of the human infectious disease. So, as you remember, 2 years ago we had pandemic COVID-19. So it would be perfect state of extraordinary measure, and we could use this state of natural disaster. But here we have to remember about the fourth slide, that yes, sure, clear, we can introduce some extraordinary measure if what we have in our constitution, what we have in our different legal acts is not enough. So if we are thinking that what we have, that a lot of tools we have, a lot of legal acts we have, a lot of tools because our legal acts we have, or we, for example, made amendments in some statutes. So probably we can think that, yes, it's for this moment, at this moment, it's enough. So maybe in 2 months, maybe in 3 months, maybe something will change and we will have to introduce extraordinary measure. And also it's very interesting because probably you heard that, yeah, this state of natural disaster would be perfect for this pandemic case. But some of lawyers said, okay, why not state of emergency? Because some countries introduced the extraordinary measure, but state of emergency. The answer is quite also tricky because in our definition, in our definition of this state of emergency, as I said before, we have something like some action against to public order or to security of citizens. So to be honest, some lawyers said that, yeah, pandemic is of course some human disease, but also it is against the security of the citizens. So yeah, but as you probably know, we didn't choose any of extraordinary measure, and we use normal legal acts, I mean statutes and regulations, and it was like that. But then few months ago we had some migration crisis near our border, because it's quite hard to say that it was on our border, so it was in front of our country. So as I said before, some threats in front of our country, it's external threat, not internal threat. But anyway, the Council of Ministry decided to request of state of emergency to our president. And finally, under our new, let's say quite not new, but under this constitution from 1997, we finally had this state of emergency. It's also quite interesting if it was the external threat, maybe we shouldn't to introduce this state of emergency. But finally we had, and because of that, we could check the procedure, how to introduce state of emergency. To be honest, in my opinion, for me, it wasn't a good time to introduce state of emergency because, as you remember from a few slides before, we had a lot of constitutional tools to resolve the problem. And I think that the good argument for that is also what happened after the state of emergency, because after this 90 days, after the 60 days extension, Parliament decided to make some amendments to our 2 or 3 different statutes. So I thought, I had thought, and I'm thinking also right now in the same way, that the state of emergency wasn't necessary. We could make some amendments before, and I think that it would be almost the same, because we had this state of emergency, but we used, for example, the normal task from normal statutes, not from this statutes of state of emergency. So it's also quite interesting. And what else I can show you? Okay, so procedure of introduction is quite complicated. So as I said before, it was quite nice that we had this state of emergency because we could check this procedure, and it seems like we could have problem. For example, if we would like to introduce a martial law because of the time. As you can see, unfortunately, the next slide is in Polish, but I will tell you everything. And so why the martial law, especially this wojenne, can be problematic to introduce? Because we don't know what will happen in the case if, for example, Council of Ministry can't meet, or, for example, can't work, and will not request to the president of this martial law or state of emergency. We don't have this procedure. So unfortunately, president, for example, wants to introduce this martial law, but unfortunately, he doesn't have the request. So it's not possible to go further. But what next? What next if the parliament can't work? That is quite clear, because this case we have in our statute. So I don't know why we don't have this case, what happened with the Council of Ministry. But anyway, so we can also ask what happened next. So the martial law is in our country from the day which we can publish the regulation in Journal of Acts. And what happened if we don't, I don't know, public, if we will not send it, or it will be something like a cyber attack? Of course, we can write it, of course, why not? But unfortunately, why we don't use the regulation from Germany. There is very clear information what we should do in this case. And a quite different story is the opposite. Like, for example, okay, we will publish this regulation, but almost in the same time, the same decide that unfortunately for same it's not enough to declare this martial law, to introduce martial law, and we would have this martial law only for 2 days, for example. Of course, it's very theoretic examples, very hypotheses, a lot of hypotheses here, but still I think that if we want to clear law, we have to find perfect solution before some action. Yes, not that something happened and then we will try to think, okay, so now we should procedure what kind of state of emergency. It would be state of emergency or maybe martial law, or we will have problem with procedure. Come on, so it's not time for thinking about it. So about the hybrid warfare, because I see that probably I have just something like 5 minutes, so some cases. Hybrid warfare, so according to NATO, but it's not the binding definition, we almost know what hybrid warfare means. So it's some military and non-military actions, including disinformation, cyber attack, sometimes economic pressure, deployment of irregular armed groups, and also sometimes the using of regular forces. So a lot of examples from the definition of aggression, to be honest. But here in this hybrid warfare, we don't need action state versus other state. As I said before, if we are thinking about aggression, we need two or more but states. So to be honest, it's very blurry lines between war and peace. So during the peace also we can find some elements of hybrid warfare or asymmetric actions. So according to our constitution, for example, this action of terrorists or this action in cyberspace is perfect examples of some elements of hybrid warfare. So we can use this extraordinary measure to fight with hybrid warfare. But if we really can introduce one of the extraordinary measure because of, for example, terrorist attack, I will show you later. So yes. So here is some legal problems. As I said during the presentation, we still have to ask what kind of threats it's direct, what kind of threats is direct external, what kind of threats it's external. What does entity mean? Also, the green people, some terrorist group, and the disinformation, cyber attacks, we don't know about skull, for example, we don't know about intention sometimes. So it's very hard to classify this kind of situation. Come on, very common situation, especially during, let's say, 10, 15 years. So because of that situation, it would be very hard to introduce some extraordinary measure in Poland. But it's not a problem at all, because as I said before, we have constitutional tools and some constitutional measure. So to be honest, maybe some normal legal acts will be enough. Maybe not. But for sure, because of this kind of problems, we could have problems with procedure to introduce martial law, especially martial law. And also, for example, we have to ask about the failed and failing states. Is they are states according to public international law? And what about recognition in public international law? It's only territorium or it's state? So if, for example, some non-recognition country, non-recognition state attacks other, let's say, country or state, it will be war. We can declare state of war against this non-recognized country, or maybe it will be, or maybe this act will be, the recognition de facto, because in public international law we have recognition de jure and de facto. So it's a lot of problematic issue also in public international law, especially right now when we are looking at Ukraine. Unfortunately, what can we do? What NATO can do? What, unfortunately, Security Council can do? A lot of years ago, it was a very strong postulate that Security of Council really need reform, and one of this reform was because of the, for example, of aggression, that they should declare act and binding definition of aggression, and also about the members of Security Council, and about above of all about the procedure. Example, how to say goodbye to country which will start the war. And unfortunately, right now we have this situation, and it's a very, very impossible situation. And I think that it's something what in 21st century, it's simply impossible to understand. So I said so because in our country, according to our constitution and also according to our legal acts, we could have problem with these kinds of cases. So according to international public law, right now we have problem with war. And it's very similar situation because we don't have good definition, we don't have good regulation, and we don't have good procedure. What we should do, like, let's say, United Nations, or about, or for example, like NATO. And some conclusion. So we have to remember about definition. And to be honest, good definition are everything. Good definition, I mean, I don't want to create every legal definition, every binding definition. Of course, not really. I need only the frame of some situation, because we have very strange age. So it's very hard to to find some perfect definition for a lot of situation, but just a frame, legal frame, would be fair enough for me. Also, some insufficient norms and regulation. We should find this, as I said before, some procedure and maybe some better regulation. On the other hand, some procedures are too complicated, too long. Probably we will not have time to organize everything. So we have to find and we have to create this kind of, let's say, just in case regulation and just in case articles. And maybe we should find something for irregular action. Maybe we should use constitutional, as I said before, and statutory measure, and it will be enough. And if not, maybe we should change the article 2028 and left only this first part in situation of particular danger without this second part. So from my side, from theoretical side, I'm done. So if you have any question, I hear. So thank you very much.
Thank you very much, Malwina Kołodziejczak, for explaining us this very important problem of the extraordinary measures in Poland, especially in this moment of our history. And I invite you to write questions or comment on the chat, or you can ask your question personally if you want. So maybe I will start because I have a lot of questions. It's very, very interesting. I would like to ask you about Russian invasion on Ukraine, of course. One of the members of Polish government, Ryszard Terlecki, said in February that in the case of this invasion and with 1 million refugees which will become in Poland, maybe Poland will impose a state of emergency or maybe some kind of emergency extraordinary measures. And today we have over 2 million refugees in Poland. And what do you think? Should this state of emergency be introduced in Poland? Because like we see in Czech Republic and in Lithuania is already done. And maybe what this emergency state will change in this situation in Poland.
Okay, thank you very much. Very interesting. So, as I said before, even this situation or our border, for me, to be honest, we didn't have any premises to introduce the extraordinary measure as state of emergency. I think that it was too early, just too early. We had more tools, more tasks from normal statutes. But in that case, well, I think that it's completely different situation, because before, even if it was, let's say, too early for me, the danger was quite particular. It was something new, and especially it wasn't something natural. Yes, it was a lot of inspiration of probably Russia, Belarus, and so on and so on. That situation for sure was particular danger. right now, of course, this situation of migrants is quite also new for us, but according to our constitution, to our statutes, it's nothing against, let's say, constitutional system, public order, and of course the security of citizens. So to be honest, we don't have any reason to introduce this emergency state. But because I'm from War Studies University, I can't say that I can't see the external threat. So if we want to think about some extraordinary measure, maybe we should think about martial law. And it wouldn't be because of the internal situation of the migrants, but it would be because of the situation in our neighbor and in our neighbors, because we don't know what Minsk is thinking right now, to be honest. So if I should choose, I would choose the martial law, but because of the war, not because of the migrants.
Okay, thank you very much. It's not the answer that I'm waiting for, but okay.
Okay. Sorry.
Thank you very much.
But okay, if I can add something more, still, please remember about this second part. If ordinary constitutional measures are not enough. So I hope that our statutes and our regulation, we have some constitutional normal measure. So it will be enough. It will be enough. I'm thinking about martial law only if something happen and will be closer and closer.
Okay, yes, I understand. So thank you very much. So if there is any questions or comments? No, so, yes, from Isabella Garbo. She is Italian from University of Milan. Welcome, Isabella. And she wanted to ask concretely, who writes the laws in Poland and the constitutional amendments in this case? Are experts properly consulted in the process of writing definitions, or is it all a matter of parliamentary committees? And if yes, how much do you believe in the role of experts rather than politicians, parliamentarians in writing the laws?
It's quite great questions, Isabella. Ciao. But well, of course, we have experts. Of course, we try to make some consultations. Even our new state about the defending of country. Even we, I mean, we professors, and here at War Studies University, we had opportunity, for example, to read it before and write some comments, and also. And the most important, it depends on the legal procedure, but the most important statutes are also under the consultate in ministry, for example, different of ministry, and also in commission. But as you said here, or I can understand it like that, even if we are asking about opinion, I mean the bodies, the Council of Ministry, for example, and the Parliament ask about the legal opinion of professors. It's always very easy to find two professors And even they have 3 opinions. So of course, in that case, they can have this one, but other professor can have completely different. And maybe after consultation, they have quite similar, but it's not really common situation. I remember one case. It was about commander-in-chief, to be honest. And I remember that one of the guy from ministry, and he was the former colonel, and he was from, in that time, he was in Ministry of Defense or maybe even Security of Bureau. And he really was sure about his opinion, really was sure. And he really wanted to introduce this kind of, let's say, definition of something on some article. And I remember it was some lawyer, great woman, to be honest. And she tried to convince him that, come on, Mr. Colonel, it's really can't be like that, because it's maybe not against Constitution, but it's really seems bad, and it's very hard to interpret. It would be very hard to clear, to thinking clear about your proposition. And for him, it was very sure that this article should seems like that. And it wasn't no doubt that everybody or some other lawyer says completely different. So unfortunately, other lawyers said, yeah, why not? We can accept this final version of this article. So we can accept this kind of proposition. So unfortunately, it's not like that the same, read and vote, and nobody ask before some expert or something like that. No, but unfortunately, where is politicians? Where we have politicians, there we have some opinions. And where we have some opinions, probably we have lawyers. And where we have lawyers, we have even more opinions. So unfortunately, it's like that.
Yes, thank you very much, Malwina. And we have one question from our Ukrainian students, which is in Ukraine, actually, Ivan Dudnik. And this is his question. In my opinion, current Polish legislation on treats, armed treats, and so on is somewhat perfect. I mean, it's designed for the 21st century treats. And what if your enemy is a country with the worldview of the first half on the 20th century? What if this is a state that does not comply with the international law, the rule of war, the Geneva Conventions, and so on? It can be a state that can jump from hybrid means to full-scale war, and again back to the hybrid means, use banned weapons while the negotiations are going. What if your enemy is devoid of any logic? Are you sure that in this case your legislation will allow you to respond effectively to such a threat? I'm talking about Russia now. Yes, we understand your question, and thank you very much. Maybe while Malwina will try to answer.
Okay, thank you very much. I hope you are safe right now, and probably a lot of people cross our fingers to close this war and to finish this war as soon as possible. But as I said during the lecture, unfortunately, we don't have good answer, because according to public international law, we don't have a lot to answer what we can do in this situation. Of course, we have legal acts. Of course, as you said, we have Geneva Convention. But unfortunately, only good sanctions can help here, I think. And unfortunately, it's like that. And in Polish case, probably we will be able to introduce extraordinary measure like martial of law in that case, and probably we will be able to declare state of war. But as you said, unfortunately, here in this situation, it's some mix of conventional war, what it was completely impossible in 21st century for me, and some hybrid warfare too. So probably we would have also mixed the legal action, but it's also quite hard, like super hard, because we have to remember that our soldiers are still thinking or training for conventional war. A lot of exercise is because of the conventional war, but not in the whole scale. So I don't know. I think that the best answer and the best solution is that even during the peacetime, we have to think about wartime, and we have to organize some trainings, and we have to prepare better law. But as you notice, even if we have some quite good law like Geneva Convention, sometimes it means nothing, unfortunately.
Okay, thank you very much. And we will continue with another question from Cezary Wygliński. And he wanted to ask, what is your opinion on the last amendment of the law on the protection of the state border? It gives de facto power to introduce extraordinary measures, ban on entry in the regions which are close to the border to the Minister of Home Affairs by a simple decree with no specified time limit.
Mm-hmm.
He works for the Commissioner for Human Rights, and it is something which is very problematic now, namely to secure the effectiveness of constitutional guarantees, which are now very often bypassed by the Parliament enacting ordinary statutory law. Advocating to the previous question, I can only say that advisory opinions of the ombudsman are often not duly taken account of.
True. Well, yes. In one part, I have to agree about the ombudsman. For sure, I agree that sometimes his voice is super important, and sometimes same doesn't concern it too. But about this amendments, well, unfortunately, it is quite of particular risk. So if we prepared these amendments before, even maybe the extraordinary measure, I mean state of emergency, it wouldn't be necessary. But unfortunately, we first try to extraordinary measure. So we first try to this state of emergency, as you know, and after that we change the law. So, of course, I agree that maybe this kind of limitation and this kind of task, maybe it's too hard, and maybe this is really some part of some elements of extraordinary measure. But on the other hand, we have to remember that the situation there, it's also very risky, and we know that it's not naturally. So I think that when we consider the human rights and we consider the security of states, sometimes also we have to remember that in that case, of course, human rights are super important, but sometimes also the amendments are necessary if we can't use the extraordinary measure in other way. And here, because during the pandemic, it was sometimes different. Here we have in statutes the changes. So this limitation and this amendments we have in statutes. So in this kind of level of legal acts, well, I think that well, I'm from War Studies University, and I think that I have to agree with this kind of amendments. And yeah, because as I said before, human rights, okay, it's very important, but we have to also remember about security of the states. So yes.
Well, this is very interesting.
Have a different opinion, and of course I have to respect it. But really, believe me that I prefer make some amendments in normal legal acts and the level of the statutes than introduce extraordinary measure when, to be honest, it's not a big deal to introduce it. Or we have to change our theory of extraordinary measure, and then, like in France, for example, when we have good occasion, when we have situation, risky situation, maybe we should, but it means that we have to really change the thinking of the extraordinary measure.
Okay, that's very interesting. So maybe one more question from our student Bohaoli. So as you said, the clear definition in law is very important, but too detailed in explaining certain situations may cause more problems. Some definitions were left ambiguous deliberately. Therefore, we just need a framework, but what kind of framework will it be, or what principles should we follow in creating or explaining laws when it comes to the emergency?
Yes, as I said before, for example, just move to the last almost slides, like here. It would be enough, like we will left only the first part of definition. So in situation of particular danger, and that's all. And then, because it's very subjective political situation side. So let's do this second part. If ordinary constitutional measures are insufficient, are not enough, because we don't know what not enough means. So this is, for example, one thing. Second thing, before amendments from 2011, we had only information about martial law and other emergency state and also natural state disaster in the event of external threats, including due to the action of terrorists or action in cyberspace. It wasn't exist. So, and the parliament added this one, and in opinion of lawyers, it was very bad move, because right now we have to think about these two action, but what about more action? Yes, and still it's very political institution. So in the end, Council of Ministers and President will decide. And this external threat, my God, for sure we have to serious disturbance. It's bad word here. Something like important. What is important? What is not important? Yes, normal functioning. What is not normal? A bit normal, completely normal. We don't know it. So maybe we should left external threat, like of course against to some action against to independence, some action against to integrity of territory, and maybe also we should left some economic reason, some political reason. Why not? But not important that with aims to crash to normal functioning of the state, some serious. So for sure this is wrong, and this external to the entities. These entities, if we are thinking about martial law only because of the action of other states, okay, we should let it. But if we are thinking about group of terrorists, group of hackers, it's not possible to introduce. So just framework would be great in this case. These definitions are too details. So yes, I know that I'm woman, and for me it's always the bad situation. Here definition is too details. Here we don't have definition, and I'm complaining. Sorry, but it's really like that. So yeah, good definition. Yes, binding definition, super cool, but only the framework.
So, thank you very much. Merci beaucoup. So maybe we will stop here, and thank you very much, Malwina Kołodziejczak, for your very interesting lecture and for explaining us this problem in Polish law and in Poland. We invite you to our next seminar on the 5th of April. We will present our recent monograph, Contested Legacies of 1989, Geopolitics, Memories and Societies in Central and Eastern Europe, edited by Nicola Maslowski and Kinga Tolbitka, with participation of Anaïs Marin, Pierre-Frédéric Weber, and Sabine Volk. So thank you very much, and have a nice evening. So goodbye.
Thank you very much, Kinga, and thank you very much, students, and especially thank you for you guys who asked me the questions. Very, very good questions. Thank you for comments, also very interesting.